Good evening and welcome to the City of Barrie's Property Standards Appeal Committee meeting. I now call the Property Standards Appeal Committee to order. This meeting is being held virtually due to the COVID-19 pandemic physical distancing measures. I will go over the rules and procedures for the benefit of the committee members, participants, and the viewing public. This meeting is being streamed live via the City of Barrie YouTube channel. All participants will be muted upon entering the meeting and throughout when they are not speaking in order to reduce background noise. All web cameras will be turned on for the committee members for the duration of the meeting. If a member needs to leave their seat, they are asked to leave their camera on so it is recognized they are away, in which case the meeting will be suspended until their return. All members of committee participating via online video conference will vote by a physical show of hands. A recorded vote will be taken by the clerk. Appellants, agents, owners, and delegations are participating via Zoom or via telephone. All material provided in written format has been provided to the committee and will form part of the meeting record. In the event of a connection or service interruption occurring that affects quorum of the committee, we may recess the meeting for up to 15 minutes to gain quorum. If quorum is not achieved and live streaming stops, the meeting will be adjourned. This hearing is being conducted pursuant to City of Barrie Property Standards Bylaw 2011-138 related to the performance of property maintenance. The purpose of this meeting is to conduct an appeal hearing pursuant to City of Barrie Property Standards Bylaw 2011-138 submitted by Mr. Perry Van Hessel, property manager of 118 St. Vincent Street, on behalf of the property owners, Hassan Hakim and Salma Hakim. At this time, will the committee support clerk confirm for the record that proper notification was delivered to the appellants in accordance with bylaw 2011-138?
Proper notification was delivered in accordance with the bylaw, yes.
Thank you. Committee members, I understand that the parties may have agreed to a resolution or they're in the process of agreeing to a resolution to this matter. So in light of this, I would propose to entertain a motion to recess the committee for a period of time to allow the parties to conclude their negotiations. Can I have a motion from a committee member to recess the committee for that purpose?
I will motion that.
Thanks, Mr. Moore. Madam Clerk, would you please record the vote for recessing the committee?
Yes. Okay, and can the members who agree to the recess raise their hands? Thank you. Okay, the motion to recess has been accepted at 6:09 p.m. If everyone just wants to turn their cameras off for a few minutes, and then we'll just let Ms. Powell pop her camera back on when they're finished. Ms. Powell and Mr. Van Kessel, I should say.
Thank you, thank you, Mr. Van Kessel. So I will call you on the bot number, sir.
Thank you, Madam Clerk. The committee is in recess.
Mr. Crabb, the committee is recessed for a few minutes. You jumped on a little bit later, so the committee's in a recess for a few minutes. So everyone's just turning their cameras off and just listening in the background. So if you want to leave your camera on, that's fine, or just turn it off. And then once the recess is done, we'll speak up and let you know.
Madam Clerk, if you're ready.
Sure, we'll just let the members of the committee get back on.
My volume. Uh-oh. Uh-oh. Sorry. The volume on my computer. Okay, that's better. Thank you, Mr. Chair. I had the opportunity to speak to Mr. Van Kessel. We were not able to come to a resolution. He wishes to present his appeal.
Okay. Madam Clerk, we're not live now, are we?
We are, yes.
We are live,
Oh.
yes.
Okay. Okay, very well. The negotiations having failed, we will then proceed with the appeal hearing. Members of committee, everybody ready? And great. Excellent. Okay. This hearing will be conducted as a quasi-judicial hearing, and each party will be allotted time to present evidence, present witnesses, conduct cross-examinations of witnesses, and make submissions as they deem appropriate. The appeal hearing pursuant to bylaw 2011-138 will now be heard for Hassan Hakim and Sama Hakim for the violation and refusal to perform the necessary property repairs and/or maintenance as set out in bylaw 2011-138, sections 19.2, 27.1, 25.1, 36.1, and 36.2. At this time, I would ask the municipal prosecutor for the respondent, City of Barrie, to please identify yourself.
It was Powell, P-O-W-E-L-L, first initial C, acting as agent on behalf of the municipality this evening.
Thank you, Ms. Powell. And at this time, I would ask the appellant or their representative to please identify themselves. You're on mute, Mr. Van Kessel.
My apologies.
No problem.
My name is Van Kessel, V-A-N, capital K-E-S-S-E-L, initial P. I am I guess the representative for the owner.
So you're acting as agent for the appellants this evening?
We weren't expecting cross-examination in this matter. I didn't even know that there was a prosecutor involved until tonight. So I guess I am the representative for the owner.
Okay, do you wish to proceed with the appeal, Mr. Van Kessel, on behalf of the appellants?
I need to speak to the owner, but is there any? Again, we weren't prepared for this. I thought we were having a committee meeting.
We're kind of halfway between a standard committee and a courtroom, in the sense that we do have a formal process and procedure that we need to follow, where witnesses are brought forward, evidence is put forward, and so forth. Witnesses, if brought forward, are sworn. If you have evidence that you would like to show, I believe there is a possibility for you to share your screen, if I'm not mistaken. I see that the clerk has appeared. So you have at your disposal all of those things, Mr. Van Kessel, to act on behalf of the appellant. You know, we can all try to work through the procedure as we go here. It's like I said, it's not a formal courtroom setting, but we do have a process that we need to follow. So I presume then you would like to proceed with this?
Mr. Dolan, I have difficulty with that. I am a licensed member of the Law Society of Ontario. I was not here as a legal representative. I was here to discuss the issues before us. And I do not have a retainer agreement with the owner. I do not have any instruction from the owners regarding cross-examination. We have not called any witnesses. Again, I was not expecting a quasi-judicial hearing along these lines. And again, I did not find out till 4:30 this afternoon that there was even a prosecutor involved.
Well, the Property Standards Committee is a quasi-judicial tribunal.
Sorry, my apologies.
I see, yeah, Madam Clerk, do you have something to add?
Thank you, Chair Dolan. If Mr. Van Kessel is not ready to proceed this evening, we could adjourn for this evening if the committee is in agreement. And we could, since they've had official notice of the meeting, I believe we don't have to send out another 2-week notice for another hearing to happen, but I want to confirm that with Ms. Powell. Just to check that with her even offline after, is maybe I'll ask the committee what they would like to do. They can either proceed or we can adjourn for this evening and allow Mr. Van Kessel to prepare, even though we asked him for evidence and whatnot in advance of the meeting. So it'll be up to committee how they'd like to proceed.
Yeah, Mr. Van Kessel, we have the other side of the coin here that Ms. Powell is here and I believe she's ready to proceed. So Ms. Powell, would the committee be able to hear your comments on Mr. Van Kessel's, he hasn't made it formally, but I believe he's probably going to request that the committee adjourn.
Thank you, Chair Dolan. Respecting this, it is, of course, Mr. Van Kessel's appeal. He filed this, the documentation specific to this. I have some documents respecting letters that he's written about the property itself. I am prepared to proceed tonight. I have my witnesses here and ready to proceed. Mr. Van Kessel is here. He has one person, I believe, here to speak on his behalf. I'm not, I can attend on another day, certainly, but of course it's a property standards appeal for a timeline extension, and time is the issue. And I leave it in your hands, sir.
Yeah. Okay. So what I'm going to suggest we do, committee members, is this. I'm going to poll the committee for a motion to adjourn, having heard Ms. Powell's submissions and Mr. Van Kessel's comments. If it is the will of the committee to adjourn, then we can adjourn the hearing to another date. Ms. Powell has made it clear that she would rather not. Mr. Kessel, I believe, would prefer that we adjourn. So it's now up to the committee to make that decision. So what I would do at this time is I would entertain a motion to adjourn the committee from any of the committee members.
Mr. Dolan, I just would like to clarify. I thought an adjournment was the end of the hearing. Are we looking for a deferral or are we looking for an adjournment?
Well, again, it's up to us as a committee how we want to proceed, having heard what Ms. Powell and Mr. Van Kessel have said. So Ms. Powell is ready to proceed on behalf of the city. Mr. Van Kessel, it would appear, is not ready to proceed on behalf of the applicant. So it really falls upon the committee to decide whether we're going to proceed in the face of what we've heard so far. I know how I would like to proceed, but it's not up to me as chair. It's up to the committee as a whole. So if there's a motion from a committee member to adjourn, then at this time, as chair, I'd be willing to entertain that.
I would just like to say to Mr. Van Kessel, coming to these meetings is valuable to everybody, and you should have come prepared. However, and I would like to add, your client especially should have come prepared. I used to sit on the Committee of Adjustments, and these are very important meetings. Not seeing your client here is not good faith. However, in the position you've explained, I would make a motion to defer this meeting.
So just to be clear, we have to be a little precise with our wording here. So your motion was to defer, but did you mean to adjourn?
As I said earlier, I wasn't sure what the exact wording was. If you're correct that the wording is to adjourn, then I will make a motion to adjourn to a later date.
Okay, so we have a motion from Committee Member Moore to adjourn the Property Standards Committee. Madam Clerk, would you please take the vote on the motion?
Certainly, but we should probably decide on adjourn for a date within the next 2 weeks or whatever, and not indefinitely. We should put a time limit to when we're deferring this or adjourning it to.
Mr. Van Kessel, how much time do you think you would need to prepare to come back to the committee to present the case for the appellant?
Do I need to summons witnesses or again?
No, this is very informal. You would just bring people to the committee meeting that are that you would consider like your tenants or the property owner or the owner of the building or whomever is involved in this property standards matter is somebody that
And-
like, but I can't really
And
direct
then
you as
just
staff.
notify, yeah, because the owner
Notify
is
them.
here.
Okay.
And so's, well, we brought him to discuss. We didn't bring him as a witness, but I can have witnesses available. So do we just
yes.
sign them up like we did
Yes.
previously?
And I would highly suggest that we don't defer this longer than 2 weeks.
That I think we're okay with that.
And I'll refer to the chair or Ms. Powell on that one as well.
So Mr. Moore, would you take that as an amendment, friendly amendment, if you want to go that far to adjourn? 2
I'm
weeks?
sorry, Mr. Van Kessel, you said earlier that the owner, you weren't available to consult for representing him, and now you've said that he is available and on the call. So I would like to withdraw my motion.
I cannot legally, as a member of the Law Society, represent him in a quasi-judicial court. I thought that we were just meeting around a table to
Understood,
discuss
but
the issue.
he can represent himself.
Okay, well, Mr. Van Kessel, Mr. Moore has withdrawn his motion. So at this point, there's no motion before the committee to vote on. But what I will do is I will ask if there is a motion to adjourn the meeting from any other member of committee. Seeing no motion to adjourn, then the Property Standards Committee hearing will continue. At this time, the floor is now open to the respondent, City of Barrie, to present evidence and to call any witnesses.
Thank you, Mr. Chair. As the appellant on this hearing, we call the officer, please, Property Standards Officer Zapel.
My name is Spencer Zapel. I'm the Property Standards Officer for the City of Barrie.
Spencer Zabel, sir, do you solemnly affirm that the evidence that you will give before this committee shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And Officer Zapel, you investigated the matter before this hearing, this committee today. Is that correct?
That is correct.
You made notes then respecting this investigation?
That is correct.
Thank you. And you've had the opportunity, there are notes respecting Property Standards Order 00067, 00100, and 00155. Did you compile all of those notes?
Yes, I did.
And you've had the opportunity to review those notes?
Yes, I have.
Have there been any additions, deletions, any alterations at all to those notes?
No.
Then what is the purpose then for needing to refer to those notes in this hearing, committee hearing today?
To refresh my memory.
Thank you. Then Chair Dolan, if the witness may be granted permission to use their notes for the purposes of refreshing their memories as to specifics.
I'm fine with that. If there are any members of committee who are opposed to that, please so indicate. Seeing none, please proceed, Ms. Powell. Thank you.
Thank you. Then Officer Zapel, I'm going to ask that we kind of go through each order individually. So if we could start with PSC 21-00067. And you have involvement with that, is that correct?
That's correct.
Thank you. Then you had cause to investigate and to issue this order, is that correct?
That's correct.
Thank you. Then could you please detail your evidence?
So on February 17th, 2021, we attended the location after receiving a complaint from the tenants, Evan and Mia.
I'm sorry, my apologies, I don't mean to interrupt. What location, please?
Sorry, my apologies. It was 118 St. Vincent Street, Unit 1 in the City of Barrie. We attended the location and the tenants walked us through the maintenance issues that they had brought forward to us. At first, they brought forward a mold issue that was found to be more of a mildew and humidity issue and not a property standards matter at that time. Next, they brought forward hole in one of the bedrooms that goes from the bedroom into the kitchen. The tenants had previously covered the hole with a piece of cardboard and tape, and so they took it off, and we were able to take a photo of it and confirm that there is a hole there. The tenants then showed us damage to the bathroom wall caused by humidity from the shower, as well as under the bathroom sink. The tenant showed us a enlarged hole around the drain pipe going into the wall and covered by tape again. And then the last item was in the bedroom, a window was taped up. And again, the tenants showed us that the window latches were broken, and if the tape wasn't there, it would just fall out of the frame. Photos were taken of each item, and we then left the location.
And that was for unit number 1, correct?
That's correct.
Now, were you, and again, just to go back, you attended to this particular location as a result of a complaint from a tenant, is that correct?
That's correct. We received a complaint from the tenants at Unit 1 at 118 St. Vincent Street.
And so they let you into the unit?
Yes, they did.
They allowed you access?
Yes, they did.
And you had occasion while you were doing your investigation to take photos, is that correct?
That's correct. Photos were taken of each item that was found in violation.
Thank you. Chair, I'd like the opportunity, if we may, to share my screen respecting the photos that were taken at the time and to qualify those with the witness, please.
Are there any objections from members of the committee for Ms. Powell to share her screen to present evidence? Seeing none, please proceed. Thanks.
If I may have your indulgence for just a moment, please. Share screen. Okay, and so can everyone see this, the photos that my screen is sharing?
There is a screen that you're sharing, Ms. Powell. It appears to have an email on it.
Okay, that is not working. Okay. Things seems to be working right now. Okay, I'm going to try this one more time. Is this screen sharing?
No, we can still see you.
My apologies. I have hit the screen share button. I'm not sure if you need to co-host abilities.
Kathy, I can share the screen from the package that you provided me earlier.
If you want to try, Terry, that would be wonderful. Because mine doesn't seem to be from 00067. It's working something.
Sorry, there's a number of pages on it. Can you share your screen?
I've never shared the screen on the webinar.
Brandy has it. She's going to share it for you.
Okay.
I'm going to share my screen. Can you see my screen?
Yes, but it's blank. Ah. There you go. That's working. Oh, it didn't work again. Does everyone can see that?
Yes, we can.
Right.
Members of committee, can you see that? Perfect.
Thank you. Then as it scrolls down back to the officers, April, can you identify this photo?
Yeah, so this one is the hole under the sink. It was covered by tuck tape there under the bathroom sink there.
So that's the hole under the bathroom sink.
Yeah, it was margined, not a clean hole around the drain pipe going into the wall.
Thank you. And can we continue on with the photos, please? And again, officers, April, can you identify this photo, please?
So that's the bathroom wall where there was humidity damage near the shower, and it's a rough, just damaged.
The damaged drywall?
Yes, that's correct. Yes.
If we can continue to the next photo, please. And this photo. Can you explain this photo, please?
Yeah, so this is a hole in the bedroom that leads to the kitchen.
And again, the date of these particular photographs are all listed on top, but just for the purposes of the record, if we can just go back, this was the 17th of February, correct?
That's correct. Yes.
And so the next photo, please. This again is the 17th of February at 10:08 in the morning. Can you detail this photo?
Yeah, that's the same hole from the bedroom looking into the kitchen.
So this hole goes from the bedroom into the kitchen.
That's correct. Yeah.
If we can continue with the next photo, please. From February the 17th as well.
So this just has the broken plastic window latch where in the bed, sorry, this is the bedroom window where the tuck tape, as you can see in the bottom of the picture there, is holding up the window due to the broken latches.
Thank you. And the next photo, please. On February the 17th, you take this photo as well? Can you detail this photo?
Yes, so this is the same bedroom window, just the other plastic latch that is broken there and the tuck tape holding up the window.
And I'm sorry, the duct tape is holding up the window?
Yes, that's correct. The window latches are, plastic window latches are broken there.
And the next photo, please. That might be the last one. Oh, one other photo. And again, this is February the 17th. Can you detail this photo, please?
So this is from the kitchen, and it's a hole that leads to the bedroom.
So that's the opposite side of the one we just saw?
That's correct, yes.
And the next photo, please. This photo was taken March the 25th. Can you detail this photo?
So on March 25th, yes, so this is the bedroom window with the same broken latch.
Now, on March 25th, you entered the unit again from the tenant?
Yes, so on March 25th, we attended 118 St. Vincent Street, Unit 1, Barrie, Ontario, to re-inspect the property and see if there was compliance. The tenants again allowed voluntary access entry, and we found that all issues were still outstanding, and new photos were taken of each item indicating that. And after that point, on March 29th, we issued the property standards order.
Okay. And is there another photo after this, please? And again, this is also March 25th. So this is the same hole that we saw before on the February the 17th. So
That's
just
correct.
indicating that it hasn't been fixed yet.
That's correct.
And if we can scroll down for the other photos, please, as I believe they're the same. March the 25th. And again, that's the same hole with the duct tape that we saw earlier.
That's correct, yes.
And again, if we can scroll down the remaining photos. It's the same drywall from the bedroom wall.
From the bathroom wall. Yes, that's the bathroom wall. The drywall there is just damaged from humidity from the shower.
And the next photo, please.
And this is the other plastic latch from the bedroom window that was broken.
And the next photo, please. And again,
This is the from the kitchen, the hole in the wall leading to the bedroom.
now is this on, I'm sorry, is this on the countertop itself or is this higher up?
Sorry, my apologies. This is in the cupboards underneath the countertop.
And the next photo, please. Thank you, that's the only photos. Sorry, continue on, please, Officer Zabel. Actually, before you do, I have one other question for you. So on the 17th of February, when you spoke to the tenants and you took the photographs, did you have the opportunity to speak to the property manager at that time or the owner of the property and advise them of these defects?
So on February 19th, sorry, a notice of violation was sent out to the registered owners of the property, as well as a copy of the notice of violation was sent out by email to the property manager, Perry Van Kessel. And on March 1st, I spoke with Perry Van Kessel, the property manager, with regards to this maintenance matter. And he advised at that time that there seemed to be some, he was seeking eviction due to several issues and requested an extension at that time of time. And at that time, I granted the extension until March 23rd, 2021, and explained that if compliance wasn't met at that time, a property standards order would be sent out. And that's why we attended on March 25th to do the re-inspection and send out the property standards order on March 29th, 2021.
And March 29th order indicated that the property had to be in compliance by when?
Sorry, 1 second here. The order granted the property owners 19 days from March 29, 2021.
And to your knowledge, has the, first of all, the copy of the order. The copy of the order that you provided, did it detail everything that needed to be done to the property?
Yes, it did. Yes, all of those issues were listed on the property standards order.
And to your knowledge, has that, those defects been fixed?
Not that I am aware of.
So if I'm understanding correctly, from the March the 29th, they would have had 19 days from that day. So that would have put it somewhere, I guess, around the 3rd of April, around the 3rd week of April. So up until today's date, have you heard of it? Do you know if those repairs have been made?
Not that I'm aware of.
Do you have any further evidence that you wish to give respecting property standards order 00067?
Not at this time. No.
Thank you. Then perhaps if we can move to the next order, please, PSC 21-00100. And if I may have your indulgence for just a moment, please. Okay, and Officer Zapel, you conducted an investigation respecting this order, is that correct?
That's correct.
Okay. Would you please nice and slowly detail your evidence as it respecting PSC 21-00100?
So on February 10th, 2021, we received a complaint with regards to low heat at 118 St. Vincent Street, Unit 2, City of Barrie. On February 9th, I first contacted property manager Perry Van Kessel and left a voicemail with regards to heat issues.
May I object? I have the notice of hearing for this hearing this evening tonight. It is for the purpose of unit number or hearing file number 0067. 00101 and 00155. 00100 is not mentioned in this appeal, and we did not prepare any evidence regarding unit number 2 at 118 St. Vincent Street.
Ms. Powell, could I hear submissions on the objection, please?
Thank you, Chairman. I have a letter dated May the 25th, 2021, sent by the City of Barrie, addressed to Mr. Perry Van Kessel, the property manager at number 8-52 Adelaide Street, indicating the Property Standards Appeal Committee for the City of Barrie would be sitting. It indicates the purpose of this hearing is to hear the appeal of Salma and Hassan Hakim as received against orders PS 21-00067, PSC 21-00101, and PS 00155. There is a misprint, but clearly Mr. Van Kessel initiated the proceedings. He filed the appeals. Certainly he would, from this piece of paper that he would have received, he would have known that he's responding to all 3 orders.
Thank you. Members of committee, you've heard the submissions, you've heard the objection from Mr. Van Kessel, you've heard the response from Ms. Powell. At this time, I will entertain a motion from any member of committee to sustain the objection. Seeing none, Mr. Van Kessel, the committee has overruled your objection, and Ms. Powell, I would ask you to continue, please. Ms. Powell, you're on mute.
Thank you, Chairman. My apologies. So Officer Zapel, we'll go back. So you indicated on the 10th of February, 2021, you got a complaint respecting low heat from 118 St. Vincent, and you attended that address?
No, well, not until later on, sorry. Between February 9th and March 4th, I had several communication with property manager Perry Van Kessel about the heat issue in the building, which we talked about several attempts to correct the issue, and he had appeared to be making some attempts to correct it. However, on March 4th, I had emailed property manager Perry Van Kessel informing that he had until March 10th to correct the heat issues in the building. And at that time, we would be conducting an inspection of the unit. And if there was a violation, we'd be sending out a notice of violation. Therefore, on March 9th, I received a email actually from property manager Perry Van Kessel with an attached report or invoice from his plumbing contractor stating the outstanding issue. And on March 10th, we attended 118 St. Vincent Street, Unit 2 in the city of Barrie. And we met with the tenant of Unit 2. We took a heat reading of both the kitchen and the sewing room. And at that time, the kitchen was 19.7 degrees Celsius and the sewing room was 19.8 degrees Celsius. However, the weather at that time was bright and sunny. We then made a re-inspection time for March 15th with the tenant, March 15th, 2021. And we left the location on March 15th, 2021. We re-attended 118 St. Vincent Street, Unit 2, and met with the tenant's representative, the tenant's sister. We entered the unit and had temperature readings of 18.9 degrees Celsius in the kitchen and 18.9 degrees Celsius in the sewing room. Upon inspection, it was also noted that the radiators were cold to touch and all windows were closed, except for one in the sewing room was slightly ajar, which we shut upon arrival. We then left the location, and on March 17, 2021, notice of violation was sent out to the property owners. On April 6th, 2021, we re-attended the location for compliance. 118 St. Vincent Street, Unit 2, City of Barrie. Again, upon arrival, we met with the tenant's representative, the tenant's sister. We took a heat reading in both rooms again. However, due to the temperature outside again, it was over 20 degrees. In both rooms. However, due to the report that was sent to us from property manager Perry Van Kessel, that was indicated that the heating system was still non-functional. We issued out the order based on that piece of evidence that was issued. And again, that property standards order was issued out on April 12th, 2021.
And how many days were allotted after April the 12th to comply with the order?
Sorry, that would be 30 days.
So the order was sent on April the 12th, so they had made until May the 12th to comply with the order.
That's correct.
And to your knowledge, has the repairs been, well, first of all, respecting the order itself, what were the specifics on the order?
So the order was respect to the invoice for the inspection report that was issued or that was sent to us by property manager Perry Van Kessel, indicating that the heating was in disrepair, and the property owner was, or the order was indicated that the property owner shall repair the heating system as recommended by the invoice or report.
Out of curiosity, repair the heating system. So this occurred on the 10th of February. I take it there was something being done to help the tenants with heat.
That's correct, yes. So it's to my knowledge that Perry, our property manager, Perry Van Kessel, was providing space heaters to his tenants and providing electricity rebates to assist with them in the temporary basis.
So the heat wasn't operational in those particular units from the 10th of February all the way up, I guess, until basically today, but there's no real requirement for heat in this weather, correct?
That's correct.
So the order was not complied with.
That's correct.
Was a reason ever provided to you for respecting this as to why they couldn't, for these two orders for the heat in both unit 1 and unit 2, why they couldn't fix it?
I do believe the reason was that Perry, our property manager, Perry Van Kessel there, he submitted an email stating that the repairs can be completed during the current heating season due to the size of the repairs that was needed.
And did you make any suggestions to Mr. Van Kessel on how to alleviate the problem, how to fix the problem?
Throughout the process, I tried, offering advice or just trying to help them along as best as I could.
So as a result of there not being any heat, that the heat not being fixed in these particular 2 units, that's why these property standards orders were issued, correct?
That's correct.
Thank you. Any further evidence that you wish to give respecting these orders, officer?
Just the invoice or report that was submitted to us by Mr. Van Kessel from J Plumbing.
I'm sorry, I didn't hear that last part.
The invoice or report that was submitted to Enforcement Services by Mr. Van Kessel, indicating that the issue appears to be a blockage within the recirculation loop and heating lines will need to be cut out to determine location.
And that was an invoice that was submitted. What was the company name?
J Plumbing Limited.
J Plumbing Limited?
Yes.
There is a copy of that order in the package that was sent to the committee members. It's also a copy of the order that was supplied by Mr. Van Kessel. It can be something that if we need to, perhaps Madam Clerk can share her screen again respecting this particular piece of paper. But the invoice indicates that the issues appear to be a blockage within the recirculation loop and the heating lines. So would that be considered a substantial repair at that point?
I would say yes. Yeah, like you're looking at yeah, a substantial repair.
Now, if I can have the court or the hearing committee's indulgence for just a moment, please. So, just as a quick question, has Mr. Van Kessel been able to provide to you a anything from any company that indicates that when they're going to start the work, or any invoice from anybody that indicates any parts have been provided, anything that says that there's a start date when this is going to be completed?
No, no, nothing that nothing that is shown since this report indicating that.
Is it fair today? It's fair to say that up until today, what you've received from Mr. Van Kessel respecting these orders is tenders and invoices and people giving explanations as to what happened and what the problem may be. but nothing concrete as to when it's going to be fixed.
Nothing concrete. No, we have not received anything concrete.
I believe I can have your indulgence again for a moment. I believe those are all the questions that I have now for Officer Zapel.
Thank you, Ms. Powell. Mr. Van Kessel, this is your opportunity to cross-examine the witness. Should you choose to do so, you of course are not obligated to do so, but if you choose to cross-examine the property standards officer, now is the time to do so. Mr. Kessel, do you have any questions for the witness?
Thank you, Mr. Chair. My apologies. Officer Zapel, what did this all occurred in the month of February, correct? Like
It started in February 2021. Yes.
Yes. During COVID. Would you agree that it was during COVID and shutdowns?
Yes. Yep.
Were you not informed at any time the difficulty in getting people into Unit 1? I'm talking about the repairs 0067. About the difficulties in getting people to enter units at that time to do repairs, the length of time involved. Did you receive any notices or emails or communications at that time explaining the difficulty in doing drywall repairs?
I understand that. Yeah, like there was a delay in for sure in contractors being able to complete repairs, and we saw that throughout all of our matters. However, you know, that's why so much time was given, and that's why an extension was given on top of the property standards notice violation.
But did not the extension still take place during COVID, the pandemic, shutdowns, and the difficulty in finding contractors or people who would enter somebody's unit?
Yeah, we're still in, yes, we're still in a difficult time for sure. And we were then, and we are still currently. Yep.
Were these repairs not, did you not describe these repairs as minor?
They are minor maintenance issues. However, they still are violations of the property standards bylaw.
You mentioned earlier that we discussed that we had other underlying problems between you and me, that we had proceeded under the Landlord Tenant Board, under the Residential Tenancies Act, due to these underlying issues that needed to be resolved in Unit Number 1. Did that not factor into, you know, we could not get, due to COVID, we could not get contractors in due to the difficulties with this particular tenant. Were you not made aware that there was actually an N5 and an application forthcoming regarding these violations?
Yes, you told me about those applications and you shared them. And that's why, again, extra time was given on top of the property standards notice compliance timeline.
If we could not carry out these orders in February, an extension to March is still during COVID, an extension even to April is still during COVID, and even an extension into this Friday upcoming is still during COVID. Would it have been any easier for us to go in that unit at any time with the tenant presenting difficulties, not only non-conforming to COVID, as is mentioned in that form, but outright refusing to abide by the rules of the Residential Tenancies Act?
My understanding is if you're having difficulty with the tenant and you need access to make necessary repairs, then a suggestion would be to contact the police and have them assist with attending.
Is it not right on the property standards page for the city of Barrie? It's one of the very first paragraphs that property standards is not there to be involved in landlord-tenant issues, and they encourage the process to go through the proper channels with the Residential Tenancies Act and the LTV. Is that not correct?
I don't know if that's on the website or not. We encourage all any tenant that calls us to do their best to work it out with their property manager or their property owner first. Yes.
And when this is obviously not happening,
then we step in. Yes.
Then you step in. But should you not still respect try and encourage some kind of settlement or between the two parties?
We do our best to sometimes we get caught in the middle. It's
Officer, I have given pages and pages of information here. You have never once supported the landlord in this issue during COVID. You've just ordered. You did not discuss, as you stated, and you were asked by the prosecutor. You never gave us any notice of order 00067 until we received it in the mail. You never called, you never informed us via email, you never informed us that anything was coming, you just mailed it. Is that, to me, to this committee, seem like cooperation?
A notice of violation being sent out is not a requirement. Like,
well, if it's not a requirement, then why would you issue an order?
We issued the order because there were property standards violations.
So you issued the order without consultation, without trying to make the situation work. You issued it and you knew the difficulties in compliance. You knew the difficulties caused by the pandemic. You knew that there is an application and an N5 before the landlord tenant board, and you still issued your order, correct?
Yes, that's correct. Yes, I issued the order.
I'd like to move on to the heating orders, 100 and 101. When you were initially notified by the tenant in number 1 that there was a heating problem in the building, were you also notified of another issue at the time?
Sorry.
I believe that was February.
February 9th.
Yes.
So we received a complaint with regards to low heat on February 9th and other maintenance issues.
Were you not informed of bed bugs as well?
Yes, we were. Yes.
Were you not immediately updated regarding the bed bugs and the situation?
Yes, you immediately acted on that and provided us a copy with that report, and that's why nothing was issued on that.
And that report was negative.
That
The
report was
complaint
negative.
regarding the bed bugs was negative.
That's correct. Yes, I recall that. Yes.
Forgive me here. I just, again, was not prepared fully for this. If the committee could go to the notice of appeal for 100 and 155, I've labeled it as appeal number 2. It's dated April 19th.
Mr. Van Kessel, would you like to share your screen to show the committee and staff and the prosecutor what you're referring to?
Sure. This is
Entire
documents that I sent.
that works. That works too.
Is that okay?
I have that notice of appeal dated the April the 19th, 2021.
Officer Zabel, I'd like to refer to tab 1. And I believe I tabbed these documents because they were mailed. Tab 1, which are all the emails that we had with Officer Zabel between myself and him between February 11th and March 9th, detailing our efforts to repair and update regarding the heating system. I'd like to go
That's
to
correct.
A.
You may, yes. You emailed, yes. You provided quite a few updates on the heating situation through that time. And I understand you were doing what you could to try to solve the problem at that time.
So just to put that on hold for a second. You were informed that the boiler had broken down and that it was the igniter that had broken on the boiler. That I had hired a contractor immediately before you were even involved to repair. Correct?
That's correct. Yeah.
Once you were involved the following Monday, you were informed that the parts, he could not find the parts, but they were ordered.
Yes, that's correct. Yes.
By the following Thursday, I suggested to you in one of these emails, I believe it's tab 1C or tab 1D. I'm sorry. You were informed that, I believe it was over the phone, that my first contractor, Jace Mechanical, that it might be months because he could not get an ETA to quote exactly on getting those parts. So I suggested to you that I would bring in a second contractor to make sure that this was the same story between two contractors. And
Yes,
that's
I recall you hired a second contractor. Yes.
And then on February 12th, they found the parts. And I updated you on February 12th that the parts were coming from Montreal and they would be in as soon as possible. And again, this is during the pandemic. This is during total shutdown in February. The borders are closed. People are scrounging and nobody's working. On February 13th, I forwarded you a copy of the rebate letter and everything to take care of the tenants. We'd already offered alternative heat source. The only heat source that could be provided were portable space heaters. And just for the committee, I'd like to explain at this time what kind of heating system we're dealing with. This is not a unit-specific heating system. This is a 70-year-old building that has a boiler that we replaced and renewed in 2004. It circulates water throughout the building. It doesn't go to this unit or this unit. I cannot control it. Even if I wanted to, I could not turn off the heat to any one unit. It also heats the common areas. Our rads, our pipes, our laundry room, our everything. It heats the entire building, all at the same temperature. The boiler went down. We knew there was no heat in the building. We were doing everything we could. We provided space heaters. We provided hydro rebates as soon as we knew that parts were going to be delayed.
Sorry, Mr. Van Kessel, could I just interrupt you for a second? It sounds to me like you're providing evidence. This is your opportunity to cross-examine Mr. Zapel. You will have an opportunity to provide evidence later if you wish, and to provide closing submissions. But for now, if you could confine your time to questioning Mr. Zapel, thank you.
But this is my difficulty, Mr. Chair. I can't question myself on evidence. We would have hired another legal representative if we had known that there was going to be cross-examination. I have nobody to explain this to. I am the head witness.
If you wish later on, sir, you may put yourself forward as a witness. That's entirely your call as to whether you do that or not. But for now, I would ask you to confine your time to questioning Mr. Zapel in cross-examination.
You agree you were provided with almost daily updates throughout the month of February?
That's correct. You provided a lot of updates throughout that time, Perry. Yes.
On March 3rd, you've previously mentioned that you received the invoice from J Plumbing. Did you receive an email from me as well describing that there was a problem with the circulation system at that point in time?
Sorry, that was on March 3rd?
It would be tab 1-0.
Yes, I briefly recall this email that you sent, this update. Yes.
And as you stated previously, if you look at paragraph 3, are you not informed that this would be that we need to find the blockage? We need to pinpoint it, and it cannot be pinpointed until after the heating season.
That's what you stated in your email.
Yes. And does it also, this email also not state that it is a huge undertaking and cannot be accomplished during the heating season?
That's what you stated in your email.
Is that, were you not, were you not aware that there was some heat, mainly on the main floor and places where there was no blockage? It was minimal, but the heating system was working.
That's what you indicated, but at that time we were looking at units 1 and 2.
Correct. So you were looking at only units 1 and 2.
That's correct. They were the ones that reported the issues.
Even though the heating system, you were aware that the heating system heated all 6 units and the common areas of the building.
That's correct. Yeah.
Do you have, did you make or have any suggestions how to isolate unit 1 and unit 2 as far as repairs?
I'm sorry, pardon?
Is there any way that we could have individually repaired the heating in those units, specific units, as you indicated?
Well, what you could have done is install, you looked at your options for baseboard heating, perhaps. It may have been your easier solution to put an end to the heating problem.
I will bring up Mr. Parker later, but the it's not quite as simple. There's also a previous letter, which I'm sure was sent to you. I can't refer to it specifically right now because I don't know which one it is, that specifically states that those units are 50 to 60 amps each, which is minimum, and that we can't put electricity into that building and electric baseboards. There are no other alternative heating systems. Were you not aware of that? The low amperage of those units?
No, I wasn't aware of that.
Do you not think it would have been productive had you have offered that suggestion of electric baseboards so that we could have explained what was happening in greater detail than we already had, which is rather quite extensive up to that point in time? Could there not have been a better effort on your part to try to resolve the problem instead of issuing orders and deadlines that you may or may not have been aware, but either way could not be satisfied?
Answer. It's not my responsibility to ensure your tenants are getting.
You issued an order that it is your responsibility to make sure those tenants have heat, and you disregarded our efforts to show you what was being done to heat those units.
I did not disregard your efforts, and not. But this issue had been going on from the beginning of February and into March. That's why the orders were issued.
Again, during COVID, with almost daily updates, telling you, informing you what we were doing moving forward to resolve these problems as quickly as possible. And you still issued the order knowing that we were making every effort to repair the central heating system in that building at the time.
Yes, I issued the order because there was non-compliance.
I have no further questions, Mr. Chair. I just, again, my apologies. I was not prepared for cross-examination or a full trial here.
Thank you, Mr. Van Kessel. Ms. Powell, do you wish to call any reply evidence at this time?
I just have three questions for the officer, if I may, Chairman. Officer Zapel, would you agree with me that construction and home repair during COVID has been sort of deemed an essential service and really hasn't stopped through this pandemic?
That's correct. It's been deemed an essential service.
Now, specifically getting into a unit, if a person has if you're an owner of a building and you have to get into a unit and one of your tenants isn't letting you in, there are ways around that, correct? You can contact the police, but you can get into the unit.
That's correct.
And the last thing that I have is sort of respecting order 00067. Mr. Van Kessel indicated that you just issued a notice of violation or just issued the order the order, but in fact, you gave him notice first by the notice of violation is sort of something that says, here are the problems. Can you please fix it before this date? Otherwise, we're going to order you to do it. Is that correct?
That's correct. Yes. Notice was issued out in that sense.
Thank you. And did Mr. Van Kessel ever provide to you anything that says, you know, I've got such and such company coming on April the 1st to fix it or May the 1st to fix it. Here's the company. Here's the date they're going to have the completed by. Anything that would indicate that these repairs were proceeding forward?
No.
No further questions, Chairman.
Thank you, Ms. Powell. Mr. Zapel, thank you very much for your time, sir. Ms. Powell, do you have any further witnesses to call on behalf of the respondent at this time?
No, Chairman, that is the case on behalf of the city.
Thank you very much. So, Mr. Van Kessel, this is your opportunity to provide evidence to the committee on behalf of the applicant. As we discussed earlier, you are, of course, not obligated to provide any evidence at all. But if you wish to provide evidence to the committee, including swearing in of any witnesses, swearing yourself in is an option should you choose to do so, then now would be your time to do that.
I'd like to call on Mr. Don Parker, if I could, please.
Okay, I'm here. Can you hear me?
Madam
Again.
Chair.
Don
Madam
Parker,
Chair,
sir, do you solemnly affirm that the evidence that you are about to give before this committee shall be the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Parker, can you please explain your position, your job, your employment?
Yep. First of all, my name's Donald Parker, and I am the owner of Georgian Electrical Contractors Limited in the city of Barrie. And of course, our main business, only business, is electrical.
And how long have you been in this business, Mr. Parker?
Since 1965.
When were you first contacted by me regarding the heating issues? Approximately, when were you contacted by me regarding the heating issues at 118 St. Vincent Street and possible solutions?
I would have to say it was sometime in April, but I don't know exactly when. I haven't made any notes. Go ahead.
No, I haven't either, Mr. Parker. If you could please explain to the committee, what have you and I and several other people done since April in order to move this matter forward so that we can have heat in units number 1 and number 2 at 118 St. Vincent Street?
Well, we definitely want to have a heat loss so we can see what the service is able to handle that you have now. And further from that, we have obtain the services of an electrical and mechanical engineer to look into that aspect. And basically that's what we're doing right now, presently.
Would you agree that several of the units were inspected for the conversion to electrical on or about May 11th of 2021?
Yes, 4 units were inspected at that time.
And did any of them have enough electricity in the units in order to supply electric baseboard heat?
No, not to meet the requirement for heat loss for those units.
So we are also would you not agree that we are also in the process of trying to get more power into the building before this building can be converted to electric?
Yes.
The electrical and mechanical reports that you mentioned that need to be obtained, are they for the benefit, who are they for the benefit of?
Well, the electrical engineer is going, and the mechanical, really, they are going to provide information that will tell us what size service we can have. And then from there, we can upgrade the service and then install electrical panels in the new electrical panels in the units and baseboard heating. But that's through the engineer's information.
Is there any other body that you need, that we need to go through in order to carry out whatever the suggestions are of the electrical and the mechanical engineer?
Yes, after we get some reports from them, we will have to contact Electra Utility and inform them of the load that is going to be in that building so that they can adjust their power grid on the street to accommodate that new load, electrical load. Does that make sense?
Yes, it does to me. And how long do you think this process would take from actually getting it carried out from the date you submit to Electra these reports? And just approximately at this time, how long would it take before Electra could bring that increased power into the building?
Well, I can't speak for Electra, but when you go through Electra, you have to give them about 4 weeks lead time. Generally, from my experience, that is usually ends up being less than that. But that being said, it could take up to 4 weeks before they even come to some sort of solution. And for them to provide the power out in the street for that building, I can't say how long that would take. That would be Electra's call.
So even to gain their approval is going to be 4 weeks from the date that the reports are submitted.
It could,
yes.
Electra. Pardon me?
To Electra. And once it's,
Yes.
once the service is in to the building,
Yes.
how long will it take, do you approximate, per unit to upgrade everything, all the panels and everything up to electric baseboard?
If we're going to take an individual unit, then I would anticipate we have to run a new cable and install a 100 amp panel, replacing the 60 amp panel. And we would also have to upgrade the disconnect switch that feeds it, which is in the electrical room. And that could take up to a week working days.
So a reasonable timeline from what you're telling me is if we have reports in a week and a half and they're submitted to Electra, we're looking at about 5.5 weeks before we get approval. We do not know how long it will take before they can physically bring more power into the building. And then each unit and the common area will take a week each, which is 7 weeks before the final unit can be completed, correct?
That so far is correct. May I also add something?
Absolutely.
The main service will also have to be upgraded, and that's going to take, well, the old one has to be removed and the new one has to be installed. And there again, you're looking at a couple of days there. You're looking at a week or more, like we'll say 6 days to remove the old service, install a new one. First, there'll be 6 units and a house panel.
Mr. Parker, do you believe that any of this could and can be done by August 31st of 2021?
In my opinion, no. We're dealing with, there's a few issues. Number one, we're dealing with Electra, and they move at their own pace, of course. Secondly, we're having trouble getting breaker panels, breakers, some wire. And I have some jobs on the go right now where we can't get panels to do them. Last week, we went out and bought as much as we could. We go to the wholesalers and ask for a 100 amp panel. They don't have them. We ask for a 15 amp breaker. They don't have them. And this is all the issues here, besides COVID, is apparently steel, I'm told. And I don't know why, but because of the steel, either shortage or something else with steel, we're having other issues there too. So we're having trouble getting material, period.
Mr. Parker, having said that, do you feel that we've made every effort, or that you've made every effort since the first inspection on May 10th or 11th to move this project forward as quickly as possible?
We've been trying to come to a conclusion not a conclusion, we're trying to get a heat loss done in that building. And getting people to do that is an issue. They don't want to go in, number one. So we've had to turn to another engineer to get the heat loss done so that we can find out where we're going with the service. So to answer your question, yes, we've been taking different avenues to find out exactly which way we're going to go with our electrical requirements.
If we do not, if we fail to accomplish putting in a new system due to the red tape and the difficulties during these times, before the next heating season, we would be very close to being completed, or probably should be very close to being completed. Will those units support space heaters over a short period of time as sufficient heat until we can have the building converted? Do you recommend?
Well, if I would say that the space heaters that you had during February, you put in space heaters, correct?
They were portable space heaters.
Right. We can give them some heat in there, but that 60 amp panel won't support enough heat on cold days, on very cold days. The only way, well, there is a way, and that's by eliminating something like an electric stove.
Yeah, which probably is not viable for an occupied unit.
No, no.
I don't have any more questions, Mr. Chair.
Thank you, Mr. Van Kessel. Ms. Powell, do you wish to cross-examine Mr. Parker?
Just very briefly, if I may, Chairman, thank you.
Yep.
Okay, Mr. Parker, so you're the owner of Georgian Electrical Contractors, is that correct?
Correct.
Okay, and it's you, I think it's just a family-run business. It's you and your son, Steve, I understand?
That's right.
Okay, now you indicated that you were contacted by Mr. Have you done work previously for Mr. Van Kessel?
Yes, we have.
Okay, so you know him, he knows your style, you know his style?
Correct.
Okay, so now when he contacted you, did he contact you towards the end of April or in the beginning of April?
I'm trying to remember when he contacted me. April.
Do you remember,
Nope.
was it after the order was issued? Did he talk to you about, well, geez, I got a violation order in, I got to get this done?
It would be after that,
After that, okay.
or around that time.
Okay. Now, have you been retained to complete the repairs at these units in this location?
Could you explain that again?
Well, has he paid you
Repeat
to
that?
come in and do the repairs and get all this stuff organized? Or has it money to come in and do these
Well,
things?
that is in the process. He hasn't given me any money yet. No.
Okay, so you're not retained to come in and on a completion date, have the work done?
I am not. No.
Okay, so when you're indicated all the information that you have now, it's more as a result sort of a fact-finding mission. You went in and took a look at everything, and this is your opinion as to what should be done.
Partially, yes. We also made some steps to upgrade the service and come to a conclusion on just exactly what heating we needed in that building. It wasn't my opinion, no.
Okay, now you indicated that before any of these things can sort of take place, that you have to have a mechanical engineer's report and there has to be an electrical engineer's report, correct?
That's right.
Okay, and to your knowledge, have those reports, have they been retained? Like, is there somebody actively making those reports as we speak?
No, not to my knowledge anyway.
Okay, so let me ask you something. If Mr. Van
Yes.
Kessel had come to you, let's say in March, when he first became aware that there was a violation, if he'd come to you in, say, the beginning of March, would you have been able to start the repairs?
No,
You wouldn't have been able to start in March.
no.
And why not?
Well, to do the repairs, you have to, I'm assuming you mean put in baseboard heaters for repairs.
Well, to begin
Sure.
any repairs, to begin to supply permanent heat to these two units, so they don't have to rely on space heaters anymore.
Sorry,
Well, to actually conduct,
Oh.
to sort of do the repairs so that these people don't have to rely on space heaters. Could you have been retained in March? If you'd have started doing those repairs, would they have been done by now?
no,
You said it's probably gonna
No.
take about 8 weeks, correct?
to 8 weeks to what?
Well, from what I'm understanding. and
sorry,
from the
you're
notes that I've
breaking-
taken-
You were breaking up, I'm sorry.
Okay, Mr. Parker, so from the notes that I've taken, you've indicated that it would take maybe 7 or 8 weeks for these repairs to be done.
That's correct,
Okay. Now,
with the proper service.
okay. Now, the other, and apologize because I'm not quite sure. The replacing of the whole boiler system and doing all that, that's a more that's a larger repair, is that correct?
Well, I'm not in the boiler business, but by the sounds of it, yes, because they have to tear the place apart, basically.
I have no further questions for Mr. Parker. Thank you, Mr. Chair.
Thank you, Ms. Powell. Mr. Van Kessel, if you wish to call any reply evidence from Mr. Parker, now is your opportunity to do so. Mr. Van Kessel, would you?
Just, again, Mr. Chair, sorry, I was not prepared for a trial. Mr. Parker, when you were called in mid-April, and I did.
Chair, if I may interrupt, and I apologize, Chair, but at this point, Mr. Van Kessel's had the opportunity to ask questions of Mr. Parker, and I've had the opportunity for reply. Should we not continue on?
We're currently hearing reply evidence from Mr. Van Kessel. Ms. Powell, you just finished your cross-examination. This is Mr. Van Kessel's opportunity to elicit reply evidence from Mr. Parker. Mr. Van Kessel, I would just indicate to please confine your questions with respect to the questions that were asked by Ms. Powell during her cross-examination. Thank you.
Yeah, no, I have no further questions, Mr. Chair.
Okay, thank you, Mr. Van Kessel. Mr. Parker, thank you very much for participating in this hearing.
Okay, thank you.
Mr. Van Kessel, do you have any further witnesses to call?
No.
Okay, thank
That's
you.
I can call myself as a witness.
That's you may do so if you wish. Please keep in mind that you'll have to be affirmed if you wish to do so.
Absolutely.
Barry Van Kessel, sir, do you solemnly affirm that the evidence that you are about to give before this committee shall be the truth, the whole truth, and nothing but the truth?
I affirm. Again, regarding I think we've already covered the minor issues in 00067. I'm just going to make a broad statement here with as much evidence as I can. As I was explaining earlier, this is a boiler system. It's a central system. It's not a specific 2-unit system. When it goes, the building goes. When the boiler goes down, it's like a heart attack. There's no blood circulating. If the heart is replaced, The problem we experienced was there's a circulation problem. And it did not, the circulation did not go through the whole building. Up until February, and I've been managing this building for 20 years, over 20 years. And up until February, if a part broke, we got it fixed, everything was fine. In this case, we got the broken part fixed. It took way longer than anticipated. The part was fixed. We're still not getting heat. The boiler system had to be drained in order for this part to be fixed. So we had drained the system, started it back up again. We also did this last November. Last November, we were totally renovating unit number 5 in the unit, and the flooring person bumped one of the rads and cracked the pipe, a connection in the main pipe. So we had the system shut down. It was actually late October, and we had the system shut down for about a week. Again, drained. It's heavy cast iron piping. The plumber was in there welding torches, forming the whole thing in order to block that repair. We fired everything up again. Then this happened, had to be shut down again. Every time you shut down an old cast iron system, the oxidization in the water, the lead, the iron, I'm hoping that everybody here has had a plumbing repair done in their house. When you turn off the water and drain the system, you repair the plumbing, you turn it back on, and the water's brown. That's exactly what's happening. Because of the age of the pipes, it's what they call oxidizing. It's not copper piping. So it's actually deteriorating the inside of the pipes. And what happened was we shut it off and turned it on and shut it off and turned it on too many times. So what that did was blocked the circulation. We suspected it was where the repair was made. Once the boiler was fixed, we suspected it was where the repair was made due to using too much solder. We informed, the boiler was fixed, I informed Mr. Zabel. We still had no circulation. I informed Mr. Zabel. We thought it might be the ballast tank. Again, I don't know if you're familiar with a ballast tank, but it's a pressure tank that keeps the pressure in the system so that it does circulate throughout the system, over and above the pumps. We suspected it might be that because we'd emptied the system and not emptied the ballast tank. So that was done. That's all of my invoice that you were provided by Mr. Zabel and that I provided to him. Still no circulation. We changed the pumps. We thought one of the pumps would be faulty. There's 2 of them. Both of them were fine. We put new ones in anyways. Still no circulation, like partial circulation. So we suspected it had to be a solder blockage in the bathroom of unit number 5. On April, meanwhile, I believe that's when, and Officer Zabel had this information, and he gave us an order, even though he knew that we were still trying to determine, and we told him, and on that invoice that he provided already to the court, to committee, it says there's a blockage and we can't do it. This is an old lath and plaster building with pipes going through concrete, under hardwood floors. It all needs to be ripped up, tore out the whole thing. It's February, and we don't even know specifically where the leak is, and we're dealing with black cast iron pipe. So that's why he was informed that this had to wait until the end of the heating season. We were hoping that it was sediment, just sediment, and I was attempting for the end of March, through the end of March, beginning of April, to find somebody, a company that could possibly flush these rads and get any kind of sediment out of them and everything else so that we could get the circulation system again. But again, a major operation. Meanwhile, we had space heaters and rebates provided to all the tenants, you know, in order to keep them through. I also mentioned to Officer Zabel a couple of times that we have pipes, exposed pipes in there. We needed heat as well. Thank goodness for a mild winter, because I would have been chasing frozen pipes all over the place and not even within the units. And we can't leave space heaters out in the common areas. They just disappear or whatever, get broken. On April, I believe it's April 10th. And to answer Ms. Powell's question, at this point in time, we believed that all we had to do was flush the system. I believe that I communicated to Officer Zabel well enough to say that we cannot correct what we think the problem with the existing system is now until the end of the heating season. But I was already looking for people to correct it by flushing the system. We didn't know. On April 10th, a leak started coming through the ceiling of the living room of unit number 5. It's under the kitchen of unit number 3. It was a Saturday morning. The tenants in 5 called me. I figured it was the kitchen. In the past, about 4 or 5 years ago, the kitchen sink had overflowed while the tenant was doing their dishes, and that had leaked down into a similar spot in the living room ceiling of unit down below. So that's what I figured it was. Tried contacting the tenant above, couldn't find. He had no answer. He wasn't there. So I sent over my son, and I sent over the plumber from J Plumbing immediately to try and track this down. And we, of course, have master keys. They both went over, they poked a hole in the ceiling to drain it. They went upstairs, they couldn't find, but nobody was there. So there obviously it wasn't a kitchen sink problem. They checked under the kitchen sink. There's no leak, there's no nothing. It was the hot water radiator. And it was, I suspected that it might be a frozen pipe because it was still fairly cool on April 10th. And that we might have finally frozen a pipe somewhere. But it wasn't. It was a heating pipe. And these were pinhole leaks on the intake pipe going into this hot water rad. I'm sure you all know what they look like, the old coil hot water rads. Pinholes mean that it's coming from the inside of the pipe, not the outside. So there was 4 or 5 of them, and they were spraying all over. And it was the intake pipe. And that was the first time that we realized that the actual pipes are corroded. We can't flush them anymore. If we renew that system with the existing pipes, even if we replace this particular piece of pipe, I had 1 this year, I'm gonna have 5 next year, I'm gonna have 20 the year after that, and we'll always have heating problems over there and floods. The system needed to be replaced. This was April, Ms. Powell. That's why we did not know that the system, we didn't even know that the system really needed to be replaced until April 15th. And I included a personal letter from my plumber dated April 15th that we sent to Officer Zabel explaining, because by this time he'd issued his order, explaining that these pipes need to be tore out. That's the only way we can fix the existing system. We've done everything we can to get the heat, but something more drastic has to be done. I called 2 mechanical companies. We're into building permits, fire department inspections, fire permits, sprinkler systems, building department, unbelievable to replace what needs to go in there, and very, very expensive, hundreds of thousands of dollars. And it just wasn't feasible. It just wouldn't work. It was the most unpractical option. So next, I called my contractor at Innisfil Air, John Lamadia, who I've been dealing with for many years as well, to see about central air, maybe a 2-furnace system. I've managed buildings in the past with 2 furnaces, with 4 units. Modern building code. As soon as we put ductwork in, go through walls, start going through floors and everything else. Again, now we're into hundreds of thousands of dollars, and 2 forced air furnaces in the area that we have provided will not heat all 6 of those units efficiently. John's exact comment was, you pretty well need to put a furnace in every unit and duct from front to back. Again, impractical. It just could not be done. Both the water boiler mechanical guys and the central heating guys said your best option is to go electric. Mr. Parker's been dealing with our family since the 1970s, early 70s. So he's the only guy I went to. And again, Ms. Powell, to answer your question, he's not somebody that we just call up out of the phone book. Don does all our electrical. Anyways, so he did not know until I said, what do you think about electric baseboard through that unit, through that building? And that's when I informed him. So it was April 15th, April 20th, somewhere in around there. It was like the 3rd week of April, more closer to the 4th week of April, when we started pursuing this electric baseboard. All 3 of those contractors told me I needed a heat loss study. So I got in contact with a gentleman by the name of Glenn Middlebrook, who's an engineer out in Utopia. And I called several other ones too. One guy was named Langford. He was an engineer, and basically priced it out. Neither of them would go to the building, which they have to do to see what the installation is. It's COVID. Neither of them would go. Mr. Middlebrook said that if I sketched it up, if I drew up plans and took pictures and did measurements and everything, he could at least get it started until COVID's over so that he could do a heat loss study. And I did include that in my evidence package, tab number 5. I am not a sketch artist by any means, but we moved forward. I got 20 pictures of the building, easily, maybe 40, showing Mr. Middlebrook everything that I possibly could. We did an inspection on May 10th or 11th. I can't remember. It's a Saturday. I gave notice to the tenant. I gave notice to all the tenants that we were coming in, why we were coming in, and how we were coming in. That notice was also specific to unit number 1. And I said, while I am there with the electrician, I will fix your window latches. We can't spend a 4-day period repairing the holes in the wall, which is the one hole in the wall is also under dispute. He was supposed to repair that because he's the one who broke the pipes in the wall. And that is all covered under the form that we mentioned with Officer Zabel. He clearly told me I'm not allowed in. He doesn't want anybody in, the whole thing. I have it recorded. It's still on my phone, that message. We did not go in. We just went in and determined what needed to be done on the main floor, the lower floor, and everything else. And we've been working on it ever since. So that's since about May 19th. Don Parker needs floor plans. Middlebrook wants floor plans. Everybody wants floor plans. The building was built in 1951. We've applied to the city. This is all my evidence package. We applied to the city on the 18th. The archives, Simcoe County Archives, my own father has tried to get into the archives. They don't even answer the phone. I mean, they're not staffed, they're not open, and they don't even answer the phone. There's nobody there. And we don't even know, there's a 1% chance that the original building plans for that building are there anyways. So anyways, I was just about to submit these sketches to, actually I submitted them to a friend of mine who's a surveyor, and he was trying to clean them up for me and do the measurements. This was a week ago. And then Don contacted me to say he's trying to get plans into Electra and what they're going to require and everything else to bring more power in from the street. Our sketches will be no good. We need an actual report signed and from somebody. So he found a Mr. Phil Pfaff, who I've been trying to contact since Monday. And he's been trying to contact me since Monday. And I've had a discussion with him. As a matter of fact, just before Ms. Powell called me this afternoon, I was talking to him at 4 o'clock this afternoon. And I'm supposed to get together with him tomorrow morning to have a full inspection done before Friday morning. He's fully aware that I need to give tenants notice to be able to get into the building. We are progressing with this. There is no ifs, ands, or buts. And I've already discussed this with the owner, Hakeem, as to how we're moving forward and what we need. I update him 3-4 times a day every time something happens. You heard from Mr. Parker how long this is going to take. That is out of our hands. We are doing everything we possibly can. I don't want cold tenants. I never did want cold tenants. I wish this all had been one stupid part that broke and there was no pandemic and we could have had it fixed in 24 hours. Again, I've been doing this for 30 years, 250 units at one point in time, and I've never, ever seen anything like what's been going on with those 2 units, Unit 1 and Unit 2, and this process of events that's been happening. I've also had some experience with property standards before, and it's always been resolved. I mean, there's never any problem. It was 2 or 3 years ago. I don't know the officer's name, but same building. I had it rented out to a guy for storage or something, and he had a buddy living in the building. I didn't know about it. The neighbor called property standards. We had it fixed in no time flat. I mean, 2 weeks. You know, anytime. Back when illegal duplexes, and everybody had one.
Chairman, I'm going to object at this point, if perhaps Mr. Van Kessel could maintain as evidence just to this one particular incident.
Fine. I'm sorry. I'm just expressing my frustration. Anyways, but I don't have anything more to say. Is that we've made every effort to do this, and we are going to continue. And that even if, you know, and that was always our intention. We never had any intention of not getting this done. That's it. I'm sorry. Sorry for taking your time.
No, that's quite all right, Mr. Van Kessel. Thank you very much. Ms. Powell, do you wish to cross-examine Mr. Van Kessel?
Just briefly, if I may. Thank you, Chairman. Okay, so if I'm understanding your evidence correctly, Mr. Van Kessel, on the 10th of April, you believe that all you had to do was just flush the system.
Up until then, yes. At that particular point in time, yes.
Okay, so all of your, everything that you've done, everyone you've spoken to from the 11th of February until basically March, April, 2 months later, you did no repairs. It was all just sort of finding out what was wrong?
No. On February 5th, I got a heat call. February 6th, I called my boiler guy. He found out that the ignition, the igniter on the boiler was gone. He ordered the part.
But the part didn't come in. The part it was going to come in from Quebec, but it didn't come in. And then it was something different.
That was 2 weeks or later, and it did come in, and it was fixed, and the boiler was working fine.
But no heat to the units. But still no heat to the units.
That's right. So therefore, we went to the next step. We went to the ballast tanks, and when that still wasn't working, then we went to the circulation pumps. And that's when we realized that there's something in the pipes. We suspected it was the repair.
So in essence, it took you from the 15th, from the 11th of February, then to the 15th of April to really come to the decision that, you know what, the system's done, it's finished. I've got to get baseboard heating in.
Yeah, until the pipe broke on April 10th, we had no idea that we could not use the existing system anymore.
Now, did you send a letter to, did you send a specific letter to the city of Barrie or to Officers April that says, it's right around that particular time that said, you know, I figured out we're getting baseboard heating in. I've hired this contractor. This person's coming in. I've got a date that I'm going to get this done.
On April 10th, we didn't know. It was only on April 10th, which was a Saturday. It was about April 15th before we knew. And that's what I didn't know what we were doing at that particular point in time. I spent the next 2 weeks trying to determine, do we replace the pipes? Do we go central air? Do we go electric? I contacted everybody I knew, and either which way we had, and started working on the heat losses and trying to determine. At that time, flushing or fixing the pipes was no longer an option. If we were going back to the pipes, they had to be replaced.
So now that you've determined what you're going to do, have you hired a mechanical engineer or hired an electrical engineer?
Don't hire.
Have you retained them? Are they making? You paid
them? Get an
them?
electrician to do the electrical work. You get a mechanical engineer to do the mechanics. The heat loss reports in this case. You hire an electrical engineer to lay out the plan for Electra so they can bring the power in from the road. So I've hired all these people.
You have something from them that says, I'm coming in on such and such a day to do this work, or this work will be completed. I'll have that report to you by the end of May or the beginning of June.
Everything has taken a step.
Everything is.
So on May 19th, we were trying to get the heat loss reports. We'd done all this private work. We were told by an engineer. Now, so then Mr. Parker gets involved. He's applying for permits and studies with Electra. They say, no, you need this. You need this. So now we're moving forward with this. We're moving forward with that.
Okay.
Up until hopefully next week, every time we've taken a step forward, there's more requirements, and we end up taking 2 steps forward, 1 step back, but we are getting there.
Okay, I'm going to ask you to look at the notice of appeal that you sent on April the 10th respecting the property standards order 00067, and I'll just show that to my screen just so everybody can see what I'm looking at. And in this particular document, sir, at page 3, sort of point number 3, called the size of the job.
Yes.
At the bottom of the page, well, actually, the second paragraph down, you say, like, I've contacted 2 professional drywallers, Mr. Scott Hunter and Mr. Ross Visconti, who are both busy and booked solid and will not touch such a small job. Then you talk about, you've also got another handyman, a Carter Van Kessel, your 24-year-old son, who also does jobs there. You've indicated Robert Middaugh, that you've asked him to do some of the work, and a Mr. Tompkins also. But as we continue down the page, sir, in the very final paragraph, it says, however, in our showing of good faith and good intent, I have noted to the owners that you have stated in this order that, quote, you may cause the repair or work to be done. The owners are proposing a solution that if you could cause this work to be done, it would resolve all matters. With you ensuring the work would be finished. So respecting the minor repairs, sir, you haven't done those, you haven't completed any of those. This letter would indicate as such that you really don't want an extension for that order, that you just want the city to come in and be able to do the repairs.
I tried doing, well, the window latch repair. I tried that again. I have also brought forward in that evidence, and this was my communication to Officer Zabel. The guy won't let us in. He's violent. He's everything. You can say we can bring in the cops, but if he doesn't want us in, we have to go through the Residential Tenancies Act. So I disagree.
Okay, but
I
Mr.
have to
Beckles,
abide by the Residential Tenancies Act.
Okay.
When I got the order for this, after all this time of trying to get things done and under all these circumstances, and the order says that you can cause these things to be done. So we were saying we'd even pay you. If you read the rest of the paragraph, it says we understand that we'll absorb costs, because that tenant has no problem cooperating with property standards, but he let us on the property.
So this particular order, you're not interested in extending the timeline of that order because you're not going to enter that apartment in that unit anyway without the police.
I have no, this is the thing. You can't call the police to force your way into somebody's unit all the time. He'll be to the landlord tenant board, which I have 2 applications on. And
Mr. Van Kessel, I put it to you, sir, that if you had repairs that needed to get done and you needed to enter the unit, as long as you gave the gentleman notice, if he wouldn't answer, he wouldn't allow you in the unit, you would need to get in, you would have to phone the police.
I suppose, yes.
I have no further questions of the witness.
Thank you, Ms. Powell. Mr. Van Kessel, you are permitted to call reply evidence. This is a kind of an awkward situation where you would be replying to the evidence that you called in chief. So if you wish to do so, I would ask you to please confine any reply evidence that you call specifically to the questions that were asked of you by Ms. Powell during her cross-examination. So if you wish to call any reply evidence, now would be your opportunity.
I think we replied already.
Okay.
Thank you, Mr. Chair.
Okay, thank you very much, Mr. Van Kessel. Do you have any other witnesses to call?
No, again, I wasn't prepared for witnesses.
Okay. Okay, sir, thank you very much. That will be the close of the appellant's case. So at this point, I will now open the floor to members of the Property Standards Committee. Should the committee members wish to ask any questions in the nature of clarification to either party. And I believe I see Mr. Moore with his hand up. Mr. Moore?
Thank you very much, Mr. Dolan. You know, I read over this case before tonight, and I actually drove the property, so I'm familiar with it. And I just want to first off by saying I don't have a lot of patience for absentee landlords or slum landlords, and I'm not painting the picture of that right now. I'm just saying that is my own opinion. I also work as a property manager, and up until March 31st, 2021, I managed the 2nd largest real estate portfolio in Barrie of 1.5 million square feet. I have several designations in property management and have dealt with all of these issues in the past. So I would consider myself somewhat of an expert. So, Mr. Kessel, Van Kessel, what designations do you hold as a property manager?
As a professional property manager?
Correct.
Just not professional. I just experienced. I've been doing this since the late 80s.
Understood. How about the owner of the property? Does he have any professional designations as a property manager for the subject property?
I don't believe so, no.
He is here tonight. Can he speak for himself and let us know if he has any professional designations as a property manager?
Are you there, Nick?
Mr. Moore, we're kind of being put in an awkward situation here of potentially having to reaffirm a witness, and I would prefer that questions of clarification be asked based on the evidence that was provided. If we could.
Okay. All right. I'm trying to base my further questions on it's relevant to having designations required to manage properties such as this, which is over 3 units and considered a commercial property. If I was to ask you what preventative maintenance contracts you have in place and how often those preventative maintenance contracts are done, how would you be able to produce a preventative maintenance contract for all mechanical, which I would consider electrical, plumbing, and heating?
We don't have contracts in place, but all those things are inspected along with fire systems, everything on an annual
Fire
basis.
systems are inspected annually. How often is your heating and air conditioning,
There is no air conditioning.
electrical inspected?
How much is you said air conditioning?
How often? Do you have a quarterly, a half a year, a 3 quarterly inspection report done?
On the heating system, for example?
On the mechanical equipment in the building?
That's the only mechanical unit, and we every fall.
Every fall, okay. You spoke that you have a number of HVAC companies that you deal with. Would you be able to give me an example? Do you have a contract with them, or are these just people in your Rolodex?
There's certain, I don't have a Rolodex. They're all people that I've been dealing with for decades.
Okay. You said you spoke to several engineers about the project. Have you ever had a building audit done for the mechanical equipment of the building? You've been a manager there 20 years. It would make sense that at some point you would have a building audit done for the mechanical equipment. And I'm not going to try to troll you here. I'm just going to tell you where I'm going with this conversation. The issue is this. If you are a professional property manager, people are paying you rent currently in the best economy in history. It's the highest paid rent in history. It is to be assumed that there's preventative maintenance being done to the building so that in the case of a catastrophic meltdown of one of your, as you put it, heartbeats to the building, you would be prepared for it. I can't remember what you said, it was a 99-year-old building. So it would be reasonable to assume that every 20 years you would do a building audit to make sure that you weren't caught in the middle of winter without heating. You have these micro holes, which I have also found because of the hard water in Barrie, throughout radiant heaters, which we also have in one of our buildings at 364 St. Vincent and I had to do a major replacement of, that you would be aware of these issues that would present themselves because you're doing regular preventative maintenance to the building. So my question is, without trolling you, is when was the last time you did an overall capital being the roof, the electrical, the plumbing, and the heating audit to the building, which would be prudent of any property manager with 20 years experience in the same building to do?
I don't know how to answer that. I honestly don't.
Okay.
I think that's for a professional as yourself, who owns 1.5 million.
I don't own it. I used to manage it, and I don't work there anymore.
That's fine. Those are regulations for a property manager who takes care of stuff like that. I currently take care of 20 units, including these 6. We have everything upgraded, up to maintenance, backwash, everything's done that needs to be done.
Well,
and
vendors get done annually. That's a requirement of the city. I'm not sure about your radiant heating system, your boiler system, if that gets backwashed every year. I mean, if it did, I don't know if there'd be a clog in it. Anyway, that's not my area of expertise. I do appreciate that. But you can see the point I am trying to draw here. And while I'm drawing this point here, Mr. Van Kessel, I'm not bragging. I'm just trying to state my credentials. I sat on the Committee of Adjustments for 8 years. I do not appreciate a proponent trying to troll a city employee. We are not here. The members of this committee are not employees of the city. We're citizens that volunteer for this job. And while we get paid very marginally. Spencer Zappel had no responsibility to advise you how to correct your problem. And I saw you trolling him, and I found that very offensive. That was my opinion. For the record, it was my opinion, but it was not his job to advise you. You are a professional or a semi-professional property manager who should be doing regular building maintenance to your property. That is not his.
Mr. Moore, I'm sorry.
Okay.
I'm sorry to cut in there, but I really think we're starting to cross a line
Okay.
here.
I will get to the end of my statements, and I'm sorry.
If you could actually just confine your time to asking questions in the nature of clarification.
I'm almost done. I apologize.
Thank you very much.
I do apologize. I'm sorry. Okay. I'm gonna play the devil's advocate here because I do believe there is evidence also on the other side. So I would like to ask, when the tenant took occupancy. Oh, sorry. I will start with. Could you explain what an N5 form is, please, sir, Mr. Kessel?
Yeah, it's for disruption of quiet enjoyment, causing damages to the unit. It's the first form in a process at the LTV.
Thank you very much. Would you consider the tenant that you were dealing with to be hostile at the time of these complaints?
Again, for unit 1 and unit 2?
Form was likely hostile, which I'm just saying they may retaliate by calling the city on you.
Yes.
Okay. I mean, I think that is reasonable to establish that a tenant who's been served with an N5 would be disorderly and perhaps call in an order. I wanted to ask Mr. Zappel that during the COVID pandemic, it is very evident that it was very difficult, albeit they may be essential workers. A lot of essential workers, in my experience, while I was still working for my former employer, the workers weren't coming to work, albeit they might have been essential, they were not coming to work. So I have a couple questions for Mr. Zappel. In the bathroom where the moisture was, it's my understanding the building code requires either a fan to exhaust the moisture or it requires a window. Do you know if there was a window or if there was a fan? And do you know if either were engaged when this moisture problem occurred?
There is a window in the bathroom. I'm not sure if the tenants were properly engaging that window when they were showering.
Okay, well, thank you very much for that. I mean, I think that it's reasonable to assume that in the wintertime, the window was probably closed and that mildew would probably build up. That is a building code issue. I don't believe it's been rectified, but based on that, it's hard to believe that someone would keep the window open during the winter, and perhaps that may be a tenant issue. I also made some notes here. Around the sink where there was tape put around, what is the official building code requirement for sealing up that opening around the sink? Would it be foam? Would they put an expansion foam in there, or would during COVID would tape be considered acceptable for as a mean of sealing that up until a repairman could get in? Or can you comment?
Again, under property standards, it speaks to any holes, defects for the wall. We haven't really put anything into place for a COVID type situation like that. But if a more, I suppose, perhaps like a spray foam would be sufficient to correct that issue for sure. It is under the sink and not visible, 100% of the time, therefore.
Thank you very much. Also, the hole in the wall, could I just understand when the tenant took occupancy and if that hole existed upon occupancy or if the hole was created after the tenant took occupancy? Maybe Mr. Van Kessel, you can answer that one.
I can certainly answer that. I again believe that's included in the N5 notice. He occupied in June 1st, 2019. The unit was completely renovated from one end to the other. He called me about this time last year. He said his sink was plugged, and anyways, he was going to try and snake it. What he did was popped off the drain in the kitchen sink. So he said he'd take care of it after I told him we wouldn't. And when he pulled the P-trap back up, he duct taped it to the bottom of the sink and he snapped the T in the wall. A couple of weeks later, my poor tenant, number 3 again, just coincidence, he's got water coming through his ceiling. So I call in the plumber, and the plumber says somebody duct taped this back up and snapped the T in the wall. It was $539. I believe I attached it in one of these appeals. And I told the tenant in number 1 that we will pay the plumbing bill if he fixes the hole in the wall. And he's a drywaller by trade. And he said he would. And he brought it up again in October when I hired him to do some drywall work in the common area in the laundry room. And he said, "Are you going to fix that?" I said, "I thought you were going to fix it. We paid the bill. So, you know, you fix it." We gave him a few dollars extra from what we were going to pay him to fix the laundry room. Everything was supposed to be taken care of. Again, now I got problems with number 1, and all of a sudden, this hole reappears in the wall. I thought it was taken care of. Quite honestly, until I got the report from Mr. Zapel, I had no idea that I thought he had already fixed that.
Thank you. Last question, and I will finish. I'm sorry for taking so much time for everybody. When I was looking at the pictures of the window latches, it did appear to me that those windows slid upwards. The report said that the windows could not lock into place, presumably going in the opposite direction. And to me, it looked like the tape on the windows could be a vapor barrier for keeping cold out. Mr. Van Kessel, could you confirm whether those windows went up or down? Because, again, I have to be careful, but if they went up, then it does not seem extremely reasonable that they need to lock. If they went down, it seems reasonable. Or sorry, the opposite way. Thank you.
Those windows are brand new windows that we put, well, brand newer now, approximately, I don't know, about 10 years ago in that particular window. Those latches, we've replaced them all along. Again, I did not know that those latches were broken. That window slides up and down and it locks. The latches go into slots.
At the bottom. So it's not required.
The bottom
to stay up, keep the heat out. It goes to the bottom by gravity. So it doesn't need to be locked, is what I'm saying. Gravity would.
I'd have to have a look at it. I'm sorry, Mr. Moore. I'm not that familiar, but I can guarantee you that tape is, and under the bathroom sink. I've never seen that tape before until I saw the pictures.
That is all my questions, and I apologize to the committee for venturing off course on this questionnaire. Thank you very much. I'm done.
Thank you, Mr. Moore. Any further questions from members of the committee in the nature of clarification for either the respondent or the applicant? Seeing none, I have a couple of quick questions. First question, Mr. Van Kessel, I just want to clarify the evidence as I understood from Mr. Parker. Did Mr. Parker, I see he's still on the call, so maybe I'll ask him directly if you're unable to answer. Did Mr. Parker indicate that it would take approximately 8 weeks to retrofit basically install a new heating system based on electricity in the house, including all of the hassles that were mentioned with respect to the permits and engineers' reports, heat loss, heat gain calculations, Electra, and all that sort of stuff? When you factor all that in, is that included in the 8-week estimate? Mr. Van Kessel, or are you able to answer that or no? If you can't, that's fine. I just
guess again. I know what you're saying, but you mean 8 weeks after the new power is brought into the building?
if you started right now today to initiate a project to retrofit this building so that it's heated by electricity, my understanding based on the evidence was that it would take approximately 8 weeks from today to have a fully functional heating system based on electricity, unless I misunderstood the evidence.
No,
I'm asking to clarify.
No, that's definitely not the case, sir. It's going to be, we're hoping late July, August before we can start working inside the building. And I think that's what Mr. Parker was referring to.
Okay, and was there any evidence given where an estimate was provided with respect to how long it might take to get a fully functional electrical based heating system in this building? And again, I understand, I heard the evidence about all the difficulties that you're having with sourcing materials and so forth, but was there any evidence provided with respect to an estimate, a time estimate?
Again, the next stage is getting the heat loss report and the electrical engineer. And I did that at 4 p.m. this afternoon. I made that phone call. So that's where we're at. That's the next step. We can't proceed any further on anything until we get those done. So that is being taken care of first thing tomorrow morning.
Okay, thanks for that. And my last question, I'll direct this to Ms. Powell. Ms. Powell, are you aware if the city's property standards bylaw has been altered in any way or changed in response to the COVID pandemic?
I am not aware of any changes made to the bylaw. I am aware that the city, when they send out their notices and orders, and they have a violation date, an end date, that they do add 5 days onto that date, just for the purposes of the pandemic and what's been happening. So they do add extra time. They don't include that in the letter, but they do add an extra 5 days. I have been informed by that from the manager.
Okay. Okay, thanks for that. Those are my questions. Seeing no further questions from the committee, at this point, I will open the floor to the city of Barrie. Should the city wish to make any closing submissions? Ms. Powell, you may do so if you wish.
Thank you, Mr. Chairman. The respondent, the city is asking this Property Standards Appeal Committee to deny the appellant's request for an extension of time. Mr. Van Kessel, the property manager, was advised in February there was a significant problem with the heat. These concerns were then reported to the city of Barrie and came to the attention of the Property Standards Office. Again, as early as April the 11th, and this began the city's interaction with the appellant. Property Standards Officer Zapel responded to the problems at the building. He has worked with Mr. Van Kessel, extending orders, extending timelines. He's done what he can. While this gentleman Mr. Van Kessel has received different quotes to ascertain things to fix the problem. Finally, on the 16th of February, it looked like the problem could be fixed. However, it wasn't. And again, things kept going over and over and over. The day came and went, and there was no communication. Officer Zapel requested an update, and finally on the 25th of February, Mr. Van Kessel responded that the problem was partially fixed and everyone had space heaters. Another month goes by, and March 25th, the emails from Mr. Van Kessel again only refer to the problems and the issues. They don't refer to any solutions. There has been zero progression, and the tenants are forced at this point to endure low heat in February and March with space heaters, which are not a long-term solution. Mr. Van Kessel believes that because he supplied space heaters to the affected tenants, the problem is not one of immediacy. On March the 4th, the officer Zapel is clear in his emails that it's already been a month. The magnitude of the repair is not lost on anyone. However, the respondent, we submit that the appellant has wasted valuable time trying to contract people that he knows or that he's previously done work for, or that even that are related to him. The need to complete the repairs supersedes Mr. Van Kessel's desires to have specific people deal with this problem. The owner is warned in early March to get the work done, and it seems that on March the 4th, Mr. Van Kessel has, as he indicates in his email, he's given up. The heating system cannot be repaired this heating season. That's not agreeable. Mr. Van Kessel is relying on error by omission as a defense to this order. He keeps answering these orders with, it's hard to find people, the job is too big, we have people coming in to take a look at the problem. All of these professional people have supplied their expertise, yet no solution has been implemented. Nobody's there to do the work. We see through the emails that baseboard heaters are a solution as far back again as the early April, yet again not implemented. This order should not be extended, order 00155 and order 00100. The order is required to get the work done. Mr. Van Kessel has not retained anyone to complete the repairs. He has requested and received quotes and opinions, but he has not implemented a solution, and it's been 4 months. The time has elapsed for deciding what to do. The city and the building need action. The committee's refusal to extend the timeline for this order commences that action. Respecting order 0067, this is an order for minor repairs that were to be completed by April the 17th. As of today, we're at June the 9th, and the appellant has had 52 days to make these minor repairs, 22 additional days beyond the order, and I submit that this is the appellant's extension of time. These are minor repairs, holes in bathroom walls and bedroom walls, latches that need to be replaced, minor things. And Mr. Van Kessel was aware of the repairs before February. In his letter dated April the 8th, little more than 1 week before the expiry of the order, he agrees that the job may take up to 4 days to complete, but he keeps making claims that the tenant, Mr. Dwinell, has contracted or won't allow people into the building or is being difficult in allowing these repairs to commence. But again, Mr. Van Kessel hasn't taken the initiative to do what needs to be done to get these repairs finished. He has many reasons for not satisfying the order. He blames the pandemic and the lack of tradespeople he knows or how busy the trades are. But again, these are not reasons to extend the order. Construction and home repair are essential services and have continued business through the pandemic. There really is no reason given for the windows or the repairs on the windows, and Mr. Van Kessel has requested latches on the 25th of February. Has that even been done? The work has been completed because Mr. Van Kessel is relying upon people, again, he has previously hired or family members. It was time last month for Mr. Van Kessel to cast his net wider to find professionals to complete the work, and he has not done so. Again, the respondent is requesting the committee deny the appeal and the minor repairs can begin. Extending the order just seems to add to the indecision. And those are my submissions, and I thank the committee for listening.
Thank you, Ms. Powell. Mr. Van Kessel, the floor is now open to you to make any closing submissions that you wish to make on behalf of the appellant.
I disagree and believe most of that has not been proven that we just heard from the prosecutor. I have done this and dealt with this on a daily basis, more than a daily basis in some cases, right from day one, as I always do with every concern. This has been a combination of events. We did not back off at any time. I did not use anything as an excuse. Everything was real, and we did provide evidence. Again, we were not prepared for a trial. I would have had plumbers and all kinds of other people here to verify the information. We came here with the intent to show that we are still moving forward and have been moving forward, and on all issues, and any repairs. The file 0067 is I've been told is irrelevant. There were small repairs. We've made efforts, and I have to abide by the Residential Tenancies Act. And I can't force my way in with a police officer every time I need to respond to something. And I definitely can't for a long period of time. I can't even get them to show up when there's drug consumption going on the property. So I highly doubt I can get them to show up for a drywall repair. Again, I think we've done our very best. We've never let this drop. We've never let it drop. We've always moved ahead long before. Anyways, I don't know. I really have nothing else to say, except I believe the timelines of Ms. Powell are very, very inaccurate. And we took all measures as the incident was happening to rectify and calm the situation as much as we possibly could under the circumstances. Thank you, Mr. Chair.
Thank you, Mr. Van Kessel. And thank you to the appellant and respondent for your submissions made to the Property Standards Committee. At this time, the committee will now move into closed session following adoption of the required motion. The purpose of going into closed session will be to obtain advice that is subject to solicitor-client privilege regarding the preparation of a decision letter concerning the property standards appeal. The closed session will not be live streamed. May I have a motion to move into closed session by a member of the committee? Mr. Moore, Madam Clerk, would you please take the recorded vote on the motion?
Thank you, Chair Dolan. Member Moore,
Yes.
Member Crabbe, and Member, I'm sorry if I mispronounce your last name, Thestley, and Chair Dolan, of course.
Yes.
And Mr. Moore. Member Moore, okay. So we're gonna jump on to another link that was a separate link that was for deliberations, and then we'll come back on to this link, or we can just deliberate and I can mail a decision of the committee out of in the next few days.
Sorry, Madam Clerk. So we're going to leave this Zoom call. We're going to go to another Zoom call where we're going to deliberate, come to a decision.
Yeah.
And then once that's done, we're going to come back on this call and make our decision public.
Yes, or you can make your decision, or there's another choice, is that we can mail out the decision to Mr. Van Kessel in the next few days once the committee's reviewed it, and then we can end this call, and then we can just stay on the other call and just we'll just have to record the meeting so that we can parse it together for the YouTube stream. So that is the committee's, if that, whatever the committee's preference is.
My understanding was that we were going to, as I said, go into closed session, make a decision, then come back on this call.
Okay.
And so I guess what I would suggest, Madam Clerk, is if it looks like it's going to take us too long when we're in closed session, then maybe we could adjourn that session, come back here, and then say that, you know, our decision will be reserved. Otherwise, I would suggest that we just make a decision in the other Zoom call, and then come back on this call and just make that decision public, unless other members of the committee don't wish to proceed that way.
I'm okay to proceed with the way you suggested, Mr. Dolan.
Okay.
I think it was just it was just an option, Chair Dolan. That's
okay. No, that's very good. Okay. Well, in that case, I will now ask committee members to log off the open session meeting and log on to the second closed session link that was provided to members for the deliberation meeting. Thank you.
Are you guys there? AJ.
So I tried getting onto the deliberation link, and it said that it wouldn't start because this Zoom meeting was still happening.
Okay.
And I see that we're still on live. I think we're still live streaming on YouTube. I'm going to assume that unless told otherwise.
Seems reasonable. Yeah, so we're getting off topic there, but I really get upset when people troll the city when they're just doing their job. So I do apologize.
Yeah, just keep in mind we may still be live streaming. So, but
Okay,
thanks.
no, I don't mind saying that publicly.
We are live streaming and we're just trying to get everything set up for the other room. It'll just be moments.
Okay,
Sorry.
so so Brandy, we'll stay in this link then until you guys let us know that you're okay for the other link.
Absolutely. We'll get you there as quickly as we can.
Very good, thank you.
Hi there. Hi, Carrie. Are we in the right place? Oh, I can't hear you. You're on mute again.
Hi, sorry,
There
I'm
you
not sure,
go.
Todd. Oh, here's Philip.
We're all good. Hi, Philip.
Sorry for speaking out of turn there, guys, but I just I was driving me crazy. You can't leave tenants without heat when they're paying rent. It's not fair.
Everyone, just a reminder that I believe we're still live streaming on YouTube right now. Just keep that in mind.
Okay. Yep.
Hi, folks. So what I'm going to get you to do is I'm going to get you to watch your emails. You're going to get a link for a separate meeting that won't be live streamed. Okay, so it's coming. So just hold it.
Oh, this is not the separate link?
Yeah, Brandy, I just received your link by email right now.
Okay, yeah, no, this is the streaming link, so the deliberations will be under a separate link. That should be coming.
Brandy, may I just ask, I don't know if this is the right form, you can stop me immediately. Are we able to, is it a set ruling, or are we able to divide the ruling up? Say there was several
Yeah,
things we agree with.
What I would suggest is those are discussions we can have in camera. Right now, we're still streaming live, and people out there could potentially be listening and watching, and that's not the intent for when we're.
I'm sorry. Okay, thank you.
So Brandy, can we click on the link that we just got from you via email, or should we wait until we close this meeting down?
Yeah, I think it works, Jay. I just did it to get onto this one. It was a second link.
So while you're in this meeting, you clicked on the link that Brandy just sent, and you're able to get onto that separate meeting at the same time?
I'm not sure. What did you do to get onto here, Jay?
I re-clicked the original link that was sent out for all of us.
All right. So leave this one, you're saying.
Brandy, can you hear us?
Yeah, he's a product manager.
I can.
Okay, so it looks like, does everybody have the email that was sent by Brandy now?
Wendy, you're not in, are you?
Because I'm waiting for the host to start.
Yeah, it says it's in progress, but I don't.
Harry?
Right.
The link
Right.
sent me takes me here.
Right.
Yeah, they are
Let's see what they say. I'm really getting worried.
working on the links.
Okay.
So Brandy, should we leave this meeting now and click on the link that you just sent us by email to join that separate meeting?
I think the host is having a little bit of an issue trying to get in, so it might take one more second. I'll be right back.
Okay, we'll just hang out and we'll wait. Thanks.
Hi, folks. It's my understanding that the committee will be able to pop into that room that was just sent to you.
Okay, thank you.
Not a problem.
Okay, so we should leave this meeting now and then pop into that separate meeting you just sent?
Yes,
Very good, thank you.
no problem.
Yeah, I don't have it yet.
Yours bounced back, so they're gonna try and send it again.
Okay, you do have the newest email address, right? Because I had an old email address on file.
Did you get stuff that I sent earlier?
I did, I got it, thank you, I got it, thank you.
He's got it.
I'm not sure if the intent is to have the applicant on the call with us while we deliberate. And with the greatest of respect to Ms. Powell, I don't think she should be here either. So I don't think we have it quite right yet.
You're still on the original.
I clicked on the link that was just provided by email.
Okay, try.
We need one of those.
Because everybody else seems to have. I will get somebody to send it to you again.
Thanks.
It's being forwarded to you again, Chair Dolan.
So
All right, we in the right spot?
We are in the right spot. It's working this time.
Good, great.
We're just waiting for the one more member to join. Oh, there's Kathy. Mr. Van Kessel, if you want to rejoin the meeting. We're just waiting for,
Randy?
we're just waiting for, no, we're just waiting for the other committee member.
Yep. All right, folks, we're just still waiting for one last committee member before we reconvene the meeting.
Here she is.
Oh, there she is. Okay, I think we have everybody here with us. So I will call the Property Standards Appeal Committee meeting back to order. Prior to receiving a motion regarding the decision of the Property Standards Appeal Committee, I will note that the city or any owner or occupant or person affected by a decision under subsection 15.3 sub 3.1 of the Building Code Act may appeal to the Superior Court of Justice by notifying the city clerk of the city of Barrie in writing and by applying to the court within 14 days after a copy of the decision is sent. At this time, I would seek a motion from a member of the committee regarding the appeal of Hassan Hakim and Salma Hakim for the violation and refusal to perform the necessary property repairs and/or maintenance as set out in bylaw 2011-138, sections 19.2, 27.1, 25.1, 36.1, and 36.2. Mr. Moore.
Thank you. Thank you, Mr. Chair. I would like to make a motion that PSC 21-100 and PSC 21-155 be upheld. I would also like to make an order from the Property Standards Committee that PSC 21-006 be amended to provide the appellant to until July 9th, 2021 to complete the repairs as stated. And
Okay, thank you for that. Just a quick point of clarification, Mr. Moore, I believe the last order was PSC 21-00067, correct? Because I think we left the 7 off of that.
I'm sorry, my apologies. give me
Just
one-
want to make sure we get the right order in the record.
Yeah. No, I'm just gonna look over my second screen here to make sure I have it right. 100. It was zero. Sorry, Mr. Chair, could you just, is it 00067 or 0067?
I have 00067. Madam Clerk, can you confirm?
Chair Dolan, it is 3 zeros and 6 sevens.
Thank you very much.
3 zeros and 6 sevens. I would like to extend the order and amend the order to provide the appellant enough time, which should be sufficient for July the 9th to complete the repairs.
Thank you very much. Any discussion from committee members on the motion? Seeing none, I will ask the clerk to take the recorded vote for this motion.
Member Crab,
I agree with the motion.
obviously Member Moore does because he's put it on the floor. Member Theslier
I agree with the motion.
and Chair Dolan.
I'm in favor of the motion.
The motion carries.
Thank you, Madam Clerk. This completes the Property Standards Committee meeting agenda for this evening. The Property Standards Committee is adjourned. Thanks very much, everybody.
Thanks very much, everybody. Thank you. Appreciate it. Thank you.
Very much. Everyone have a good evening.
You as well.
Thanks for your comments, Mr. Moore.